Welcome everybody. I'm Douwe Korff. I'm the chairman of this panel, and some of you have already seen me elsewhere. I'm a European data protection and human rights lawyer. Rachel, next to me, Rachel Brand, is the monitor, and she will introduce the panel. I think this is a particularly interesting session. I think we must be grateful to the US mission, to the EU, to step into this den of lions and wolves who might all be screaming at them. But in fact, as I said at the other panel yesterday, we Europeans can't be all that glib about our own surveillance practices. The important thing is going to be in the transatlantic intelligence relationship, how on both sides of the Atlantic we can bring the intelligence services and their practices within the rule of law. Now that is not easy, partly because there are different concepts of some fundamental elements of the rule of law on the two sides of the ocean. And I hope that the panel will be able to address a bit of that as well. One particular principle that we're having difficulty with as Europeans is the non-application of some constitutional guarantees in the United States to non-US persons. And that carries through to the Judicial Redress Act, which provides for some rights, limited rights, too limited in my view, for EU citizens, but no rights for non-EU citizens that are still protected by the EU Charter. I hope that the kind of people we have in the room here know what I'm talking about. The EU Charter protects everybody within the jurisdiction of the EU, whether you're a citizen or a national or not, whether you can be a refugee or a student from China or a businessman from Australia working in the EU, and your data are protected. And under the Judicial Redress Act, as I understand it, those non-EU citizens protected by the EU Charter would lose their Charter protection if their data go to the United States. That's a big problem. I think there are problems within the EU, in particular with the national security exemption in the EU treaties, which in my opinion are unsustainable and blow a hole in the EU legal framework, and maybe that can be discussed as well. There are serious deficiencies in the laws and practices of all the intelligence agencies on both sides of the ocean, and in some regards, the Americans have been shown to be more willing to move forward in a positive direction than some Europeans have, and that is an issue worth noting. Particular problem I have had is with what you might call extra-legal practices that are either directly outside the law or that require very innovative interpretations of the law that nobody was aware of. And again, that may be possible to discuss that. Well, plenty to discuss, and I hope we'll have a good debate. I'm going to try and stop the presentations at 12:30 so that we have half an hour for questions and answers, but it may slip a little bit. Rachel.
Thank you, Douwe. I think we may need a little more time than that with the moderated discussion, but thank you all for being here. I'm Rachel Brand. I'm a member of the U.S. Privacy and Civil Liberties Oversight Board, and thank you to the CPDP for convening this discussion. As I'm the moderator, I'm going to leave most of the speaking to the panelists, but I do want to say a couple of words about the agency that I serve in the U.S. government, what it is, and the context for this debate. So it's good to come together. We, on both sides of the Atlantic, are grappling with that fundamental question of how to balance the need to protect our citizens and preserve their way of life with the need to protect them from the state's encroachment on privacy and civil liberties. For us in the United States, as I think is true in Europe, it's not a new question. The name of this panel might suggest that this is a new question in the last 2 years, but we've been thinking about it since at least 1791 when we ratified the Fourth Amendment to our Constitution. Of course, in the 1970s, we fundamentally altered the intelligence agencies in the U.S., creating the FISA court, creating the Congressional Intelligence Committees, and increasing the oversight mechanisms and the rules that apply to the intelligence agencies constantly since the 1970s, including additional revisions in the last 2 years. And I know that this is not a new discussion here in Europe either. So my agency is one of those additions to the constellation of oversight mechanisms in the United States. We were recommended originally by the 9/11 Commission, as we called it, which was a temporary U.S. government commission that investigated why our intelligence agencies failed to prevent the terrorist attacks of 9/11. And while recommending a number of ways to increase our counterterrorism authorities, the Commission also recognized that with increased authorities goes a potential risk for encroaching on privacy and civil liberties. And so it recommended that Congress create an independent board, which originally was not independent but now is, to oversee the counterterrorism functions of the government from a privacy perspective. In 2007, Congress created my agency, we call it PCLOB for short, as an independent agency in the federal government, which means although we are in the government, we're independent in terms of our policy analysis from the president. We're 5 members. We're appointed by the president and confirmed by the Senate, but the president is required to appoint at least 2 members from the opposite political party, which is part of the independence. So I, for example, am not from the same political party as the president. And the 5 of us are independent from each other, too. We have a diversity of views on the board. We serve 6-year terms, which extend, of course, beyond the term of the president. So in terms of doing our work, we oversee and provide advice on the full gamut of counterterrorism programs in the U.S. government, and we have access to classified information that we need to do our job. So all of us, all 5 board members and all of our staff have the highest security clearances which we need to do our job. And so that independence, that access to information have enabled us to investigate some of the programs that were leaked over the last couple of years. We've issued public reports on some of them, including a very lengthy public report on the 702 or PRISM program, which if you haven't taken a look at, I would encourage you to do. And because we are a permanent agency of the government, we're continuing to look at additional surveillance authorities, including Executive Order 12333. Now, like I said before, we are only one of many oversight mechanisms in the U.S. government. And in the moderated discussion portion, I plan to ask the panelists about how you do oversight well, because there's a difference between more oversight and good oversight. So I hope the panelists will be willing to talk about that. We have a good panel. All the panelists are well qualified to talk about the full range of issues here. I'll just introduce them in order. Alex Joel serves as the Civil Liberties Protection Officer in the Office of the U.S. Director of National Intelligence, or DNI, as we call it. The DNI is the overall policy coordinator of U.S. intelligence activities, agencies rather, and their activities. Joanna Cavan will speak next after Alex. She's the head of the UK Interception of Communications Commissioner's Office, or IOCCO, whose statutory oversight jurisdiction covers not only intelligence agencies, but also police forces and other governmental authorities. Eduardo Ustaran is a partner in the Global Privacy and Information Management practice of Hogan Lovells in London. Qualified as both a Spanish abogado and an English solicitor, he advises companies operating internationally on privacy strategies. And our last speaker will be Caroline Wilson-Palow, who is the General Counsel of Privacy International, an NGO that focuses on privacy issues. She's a US-trained lawyer with experience in litigation involving privacy and intellectual property. So we'll begin with brief opening remarks by each of the panelists, hopefully only about 6 minutes, after which I will direct some questions to them for some discussion, and then at the end there will be time for questions from the audience. So we'll start with Alex Joel.
Great, thank you very much, Rachel, and it's a pleasure to be here again. I was here 2 years ago in January 2014, and it's great to come back, and I wish I'd had more time to attend more of the panels. Just a little bit about my office. So I'm the Civil Liberties Protection Officer, as Rachel has mentioned, for the Director of National Intelligence. My position was created by the same law that created the Office of the Director of National Intelligence. As Rachel said, the DNI coordinates the activities and the policies of all of the elements of the intelligence community inside the United States, to include the one that people have been talking about here mostly, which is NSA. I work very closely with those agencies. My main responsibility is to work with them on their policies, their procedures, to ensure that they include adequate protections for privacy and civil liberties. One of the big things that I've been working on recently has been efforts to make the intelligence community more transparent. So one of my additional hats in the intelligence community is to serve as the transparency officer for the Director of National Intelligence. And in that capacity, I've been working with intelligence agencies to figure out how they can be more transparent, provide more public information, while at the same time preserving the secrecy that is essential to their effectiveness. So this has been a very difficult task, but we have done a lot of work on it. We have more work to do. There have been thousands of pages of documents that we have reviewed carefully, redacted classified information, made declassification decisions, and released them to the public. And they're available on the website IC on the Record. That's one of the big changes. Let me just sort of jump into what the title of this, which is the last 2 years. I mean, I think as Rachel has said, we've been having this conversation about how to balance security and privacy for much longer than the last 2 years, but certainly in the last 2 years it's been extremely pressing on everyone's mind and the topic of a lot of debate. One change that I've seen in the last 2 years, so I spoke here in January of 2014, and at that time, when I looked at the agenda for all of the programs and panels for CPDP, I didn't see intelligence oversight really reflected in those panels. Maybe I'm misremembering, but I just don't remember that being a common topic of discussion. And now I see that it is very much being discussed here at CPDP. So I think that's one change. In fact, the panel just before us was an excellent panel talking about intelligence oversight at the member state level. And your comments as well reflect this awareness of this being a common requirement for democracies and a common challenge, which is how do we balance that security, the responsibility to protect people with the need, as Rachel pointed out, to ensure that we don't infringe on people's rights as we're carrying out that responsibility. It is a very difficult one. There are so many changes that happen over time that you have to be flexible. You have to be very tied into what the intelligence agencies are doing, changes in technology, changes in the threat situation. I mean, we've seen a lot of threats over the last couple of years and how they've manifested themselves in different ways. In the United States, of course, most recently we've had the San Bernardino attacks, which was a very shocking development for us inside the United States. Prior to that, in the last few years, we've had the Boston Marathon bombing. We've had numerous other incidents that have struck at the security of the country. And of course, in Europe, just in the past year alone, a year ago, the horrible event in Paris with the Charlie Hebdo attack, and then of course more recently again in Paris, the horrible attacks of a few months ago. So it's been a threat environment that has caused the agencies to continue to make sure that they're doing what they feel they need to do, and at the same time we are dealing with demands for transparency and privacy. I thought I would just quickly look at what the President's announced, what I came here actually to talk about in January 2014, and see how we have adjusted to the needs of the moment over the last couple of years. So the President, in his speech, President Obama in his speech in January of 2014, announced the issuance of Presidential Policy Directive 28. In doing that, he recognized both the importance of our continuing to be able to be effective in conducting intelligence activities, as well as the absolute requirement that we do so in a manner that retains the trust not only of the American people, but of people around the world. He stressed that it is not our intent to do indiscriminate surveillance, to look at the communications of ordinary people. He wanted to find ways to provide that reassurance in the structure and procedures of how we actually conduct the business of intelligence in the United States. And so he announced, he issued this directive. This is a binding directive on the intelligence agencies. We have spent the last 2 years working on it to implement it. Agencies have published their policies on it. One of the key protections, for example, is to find ways to provide equivalent protections to people regardless of nationality in terms of how we handle the data. There's also been restrictions on collection, the involvement of senior policymakers, the requirement that they consider risks in those intelligence collection activities, including risks to privacy. And there is also a review process to verify that we have in fact complied with what the policymakers have decided we should be doing in the intelligence area. One of the other big things that he called for was a transition away from the bulk telephony metadata program that people were talking about at the time. In the United States, we called it the 215 program, and that shift has happened. The program has been terminated. There is a new law in place that requires, that prohibits future such collections of business records from U.S. companies under the authorities that apply in that area. And instead, the companies retain the data. There is no data retention requirement. There's no period by which they are required to retain the data, and the intelligence services must provide them with court-approved individual selectors to obtain individualized responses. So that's been a major reform. As part of that same act, it's called the USA Freedom Act, There is now a panel of advocates, we call them amicus. These are expert attorneys whose job it is to argue the privacy and civil liberties side before our Foreign Intelligence Surveillance Court. That's something that the President called for in his speech, and it's something that is now in law. He also called for additional transparency, and so I mentioned that at the beginning. I've been involved in leading that effort across the intelligence community, so I'm happy to talk a little bit more about that. The United States, the USA Freedom Act also calls for this transparency. It mandates it. We have to review any opinions of the Foreign Intelligence Surveillance Court that are significant legal interpretations or novel legal interpretations as determined by the court. And then we have to publish them either in redacted form, or if we can't find a way to redact it, then we have to find a way to summarize it. So that is a requirement that we have. There's also statistical reporting requirements in terms of how many orders and how many targets have been served on different companies. Let me just say one other thing about oversight. I know I'm talking too long here, which is that what Rachel was mentioning in terms of having people who have the security clearances to see the information. So I think sometimes I hear criticisms, for example, of the Foreign Intelligence Surveillance Court that it is a secret court and that its decisions are secret and its proceedings are secret. And in my view, that is exactly what you need. You need a body that's going to conduct oversight that has access to the classified information, that can see the most sensitive data that the intelligence agencies are dealing with, that can have briefings and see the techniques and understand how those techniques work in order for their oversight to be effective. That said, we have to find ways to be more transparent about everything that happens. But you do want oversight bodies, in my opinion, to have the clearances to see the data, so that's not a barrier for them.
Thank you. Well, I'm going to try and provide a UK perspective on intelligence reform, and I think it's fair to say we're at a rather earlier stage of reform to the US. We've had 3 major reviews in the UK of our surveillance laws, David Anderson QC, the Intelligence Security Committee, and the RUSI review. And those reviews were comprehensive and made hundreds of recommendations between them. And significantly, in addition to the reviews, we've also had a number of cases brought in front of the Investigatory Powers Tribunal by Privacy International, Liberty, and other NGOs. And those cases, as well as challenging actually the adequacy of the current laws, have also led to the avowal of a number of powers that were exercised previously under vague statutory frameworks with very little or no transparency. So that's a really positive thing. So I think the government's response in the UK has been to publish the Investigatory Powers Bill in November. And the idea of the bill is to provide legislative clarity to this very intrusive area of surveillance. The Investigatory Powers Bill is a really complicated and significant piece of legislation, and although we welcome the UK government's efforts to put all of these powers on a statutory footing and to enhance the safeguards, we do have concerns about the really aggressive timescale. The bill is being scrutinised at the moment by a joint committee of Parliament who are due to report in February, and also the Parliamentary Science and Technology Committee have looked at some of the technical aspects, and they're due to publish their report on Monday. But what I thought I'd run through is the 3 key principles which we feel should flow through the Investigatory Powers Bill, and I thought I'd score each of those principles out of 10 in terms of how well we think the current draft deals with each of those areas. So first of all, on legislative clarity is the first area. The second area is accountability, and the third area is transparency. So on legislative clarity, that's about satisfying the rule of law. It's about ensuring we have adequate human rights protections and foreseeability. There's been a lot of debate about the IP bill in terms of whether it should be technically neutral or not. And I think someone once said to me that you don't need a law that mentions every single type of technology in order to enforce privacy. But then on the flip side, if you don't have specifics about the technology, how can the law be sufficiently clear about what is permitted and pass the test of clarity and foreseeability? So what would I give the IP bill on legislative clarity? I'd probably give it a 7 out of 10 right now. I think for the first time, all of the powers are set out, but how could we get it up to 10? At the moment, some of the surveillance authorizations are outside of the IP bill, so I think if you brought in Part 2 and Part 3 of RIPA into the IP bill, that would help. At the moment, you've got confusing disparities and a lack of clarity over equipment interference and some of the other powers because they're not all brought into the one piece of legislation. What else can they do? Publish codes of practice. The devil really is in the detail. And also there's been a huge amount of debate in the UK about the judicial review principle and the introduction of this principle into the law. And I think although that's very important, I'd like to make the point that actually the judicial commissioners, as proposed, would only be approving actually under 2% of the authorizations under this Act. And there's actually 90-odd% of the authorizations would still only be subject to post facto oversight, and that's why the Commission, the legal mandate of the Commission and not just the Commissioners is very important. So I think secondly on accountability, we really welcome the move to creating one oversight body in the UK, even though that means our office will effectively be disbanded. But I think it's a really great opportunity to address some of the gaps and overlaps that we've highlighted to the various reviews in oversight. We published a wish list of what we felt the oversight provisions should contain in order to strengthen the oversight. And we're a little bit disappointed that our wish list hasn't been delivered. You can have a look at that on our website. There were 6 key elements of our wish list, and actually 3 have been kind of partly achieved, and the remaining 3 haven't. So I think on accountability, I'd probably give the bill 6 out of 10 right now. I think we can get there. The first point is around making sure the funding and appointments structure is right for the Commission to ensure independence. Another area is to give the Commission proper remit for thematic reviews and investigations and inquiries and access to technical systems. We've also got a number of concerns around the clauses for error reporting and the very high threshold that's been set for individuals to seek effective remedy. So we've put some of those elements in our evidence to the Joint Committee, so please take a look. And then the final area is transparency. And we'd probably give the bill 7 out of 10 right now on transparency. I think there's some positive steps here. Again, only yesterday, the government, the Home Office, published some examples of operational case studies for bulk surveillance powers. And this is really welcomed, as are the relaxation in some of the secrecy provisions in the IP bill. And really, the culture of secrecy by default has got to continue to be challenged, and transparency really needs to be encouraged where it leads to greater accountability. So I think in terms of improving transparency, we'd like to see greater statistical requirements in the bill, and we'd like to see better error reporting provisions. So overall, I think we're at the very early stages in the UK of this intelligence reform, and although there's been some really positive steps taken, there's much more work to do to ensure the legitimacy and the adequacy of the powers and safeguards proposed. And really, although the timescale for this in the UK is incredibly aggressive, I want to be optimistic, and there is still time for everyone to input into this review. And the government really is only going to succeed if they have the views from civil society, telecoms companies, oversight bodies, independent reviewers, and others. The list goes on. But I think if we can all have a voice in this, then there's still time to effect positive change and to make the IP bill a really great piece of legislation. Thank you.
Thank you very much. Well, I find myself here strategically in the middle, which is interesting because I think one of the challenges of this topic is how polarized it is. It's a global issue which is polarized, so it's got all the difficult ingredients of the challenges to be resolved. I wanted to illustrate this by giving you a couple of quotes I've come across recently. One says that the powers to intercept communications, acquire communications data, and interfere with equipment are essential to tackle child sexual exploitation, to dismantle serious crime cartels, take drugs and guns off our streets, and prevent terrorist attacks. Any guesses as to who may have given that statement? What's your guess? I'll give you another one. I do not want to live in a world where everything I do and say is recorded. That is not something I'm willing to support or live under. Any guesses as to who said that? So the first one was mentioned at the beginning, in the foreword of the IP bill that we've just been here about, by Theresa May, Home Secretary of the UK. And the other one by someone who has proved to be a little controversial, called Edward Snowden. And you may think whatever you may want to think of these two individuals. And I'm sure even within this room, some people will like one, some people will like the other, and vice versa. But the point is, even at perhaps these ends of the spectrum, if you want, and perhaps there are even more radical views than these ones, but just to illustrate this, the point is that they are both right. I think they are both right, and I'm looking at this from a very objective point of view, in the sense that if we didn't really know who these people were, and we just hear that, just having a Belgian beer here, we would probably say, yeah, that's a point. And the reason why I'm highlighting this is because we hear a lot about striking the balance and finding the middle ground and so on. And yes, I guess that's where we have to be. But the question is how? How do we get to that middle ground? What's going on in the world to put us in that position? Or how do we, I think we need to justify it, but also we need to make it work in practice. And of course, I'm a lawyer, and when lawyers look at challenges and things like that, we think that possibly the best way to resolve that, apart from having a fascinating academic debate, is to leave it to the courts. The courts are there, and have been there for centuries, precisely to get the balance right. That's, for anyone who studied history in school and studied the separation of powers, that's the whole point of having courts. And of course, in Europe, we have some very senior courts or high-level courts, like the European Court of Human Rights, the Court of Justice of the European Union, which have taken a view on this. And perhaps if we just think for a second about what position the Court of Justice of the European Union has taken on this, they haven't said, oh, we must outlaw all surveillance. Or they haven't said, well, come on, rights are for wimps. They've said, we need to find the balance. And actually, they've given us some clues. So when looking at how to address this, I would like to highlight some of the clues that we've received from the European Court of Justice. The Data Retention Directive a couple of years ago is full of them. It talks about how to get the scope of the data retention right. And again, you can expand that to data collection, anything to do with data. But the idea behind or invalidating the Data Retention Directive was that it was not meeting any of these criteria set out by the Court of Justice. They said not all data, perhaps, should be retained, or at least it hasn't been explained to us why all data, or has anyone actually thought about exactly what data is useful for what, which was linked to another criterion laid out by the Data Retention Directive ruling, which was the triggers for access to the data. They said, well, where's the justification? Is there a clear enough justification for this? Let's think about under what specific circumstances data should be access, data can be accessed. And again, they sent every single country in the EU back to the drawing board on that one. They also said, what about the actual retention period? Because we're keeping the data here for up to 2 years, up to 24 months. Why 24 months? Why not a year? Why not 3 years? What is the magic limit of 24 months? Maybe it's too long. Maybe it is not too long. But how do we prove that? And again, that tells us a lot about how to apply this criteria. And of course, perhaps the most important of all, and Joanna referred to this in the context of the IP bill, is oversight. How do we ensure that ultimately, when these things happen because they need to happen, and a decision has to be made by someone to say, look, we really need this data, is that who has the final say in saying, yeah, we really need that data? Oversight and redress for individuals, that is another element. And time again, since the 2014 decision by the European Court of Justice on this point, we've seen how European countries have actually got it wrong. And it's been the courts, the constitutional courts, the supreme courts of different countries, in Austria, Slovakia, Slovenia, Romania, that time and time again have looked at this and said, this is going too far. This is going too far. In Romania, it happened twice. And we find ourselves in this situation where the courts are laying down the principles and even applying the principles on how to get that balance right. And I think that is a very important point of reference. We'll see what happens with the IP bill. We are still at the stages where the courts are not involved. The legislators are involved. And of course, that's the first step. But let's see what role they actually have, the judiciary actually has in that process. And the final point is that, my final message is that intelligence and surveillance on the one side, and then data protection and privacy on the other, they are actually compatible, you know. They really are. And the courts prove that they are compatible. They are compatible. The courts are not saying you cannot do or you cannot, or the other one doesn't matter. The courts are saying, in this particular case, this thing went too far, or this thing didn't go too far. So if we look at it from the point, I mean, by the way, these are principles that we are all very familiar with. So practical pointer here to anyone in the audience who faces requests for data from government, from law enforcement, think about it. Maybe it's a yes, maybe it's a yes but it is possible to apply data protection principles and still have intelligence, in my view. Thank you.
Caroline. Great, thank you. There we go, I think. Thanks very much for the opportunity to speak here today. I think I would echo a bit of what Eduardo just said, and I think other people on the panel, that over the last couple of years we've seen some positive developments. We've just definitely seen changes on both sides of the Atlantic when it comes to the protection of privacy, but we're not all the way there yet, and I think that we definitely still have a lot of work to do. On the previous panel, in discussion particularly around what's happening in the UK and the IP bill, Carly, my former colleague, pointed out that what's happening in the UK at the moment is that while there has been more transparency around the types of activities that the intelligence service and the police are engaging in, there hasn't been a lot of critical focus necessarily on whether or not the scope of those activities are appropriate. And the IP bill in many ways just enshrines in law practices that we think don't necessarily accord with what's happening at the European Court. In particular, right now, the course of travel of those cases. So I think it's really an interesting tension right now, what's happening at the national level versus the international level. And just to dovetail a little bit with what Eduardo just said, as far as the European courts, both the European Court of Justice and the European Court on Human Rights, I think are going in a good direction at the moment from a privacy protective perspective. A number of recent cases coming out of both courts are putting more and more focus on individualized suspicion in the context of surveillance and the need for that individualized suspicion. They're also looking and putting more focus on judicial authorization as a necessary safeguard in the context of any sort of surveillance. And I think that direction of travel, well, we're not quite all the way there yet, and we might be getting there actually relatively soon, because we at Privacy International have a case teed up on mass surveillance and intelligence sharing coming to the court soon. That's in conjunction with Liberty, Amnesty International, and others. And there's a case with Big Brother Watch and others, and another one coming out of Sweden, all on these issues. We may very soon be hearing from the courts on the question of bulk collection, mass surveillance, and how and whether or not they're actually consistent with human rights. So I think that's going to be quite interesting. But I think Eduardo has drawn the distinction well between what the courts are doing and how they're striking that balance, and what the legislatures are doing. While on both sides of the Atlantic, again, we've had some positive developments, I don't think we are all the way there. In the US, certainly, the rolling back of the Section 215 powers, the bulk telephony metadata collection, was a great development, and that actually contrasts, interestingly, to what's happening in the IP bill, where they've put bulk acquisition of communications data into the bill as an explicit power, and that is targeted towards UK citizens. So it's a very interesting contrast between the two. On the other hand, though, PPD 28, this presidential directive that is attempting to extend a few more protections to foreigners, I don't think goes quite far enough. I still think there's a really interesting question, both in the US and the UK, about redress, especially for foreigners, and how they seek that redress. We have taken at Privacy International cases within the UK, especially because we're able to get into the investigatory power tribunal, since its standing requirements are relatively low, and there's not, its standing requirements are relatively low, and we can go in and get the consideration of the issues. And I think that's actually moved the law forward, as far as Joe mentioned, bringing the IP bill to the fore. Whereas in the US, we're not seeing that. We've been following quite closely the type of litigation that's happening there. We're not seeing a lot of cases proceed, and I think that standing bar, and then concerns around national security and what evidence might be admitted in the court once, even if you get past standing, is going to make the redress question really concerning, even if, especially for foreigners, but even if foreigners can get into court in the first place through, for instance, I've heard suggestions that there are statutory provision under FISA for foreigners to potentially bring claims. So those are two issues that I think we need to take a continuing look at on both sides of the Atlantic, redress and this idea of bulk powers, and how and whether the laws are going to do anything to try to restrain the power of government, and the courts are going to do anything to try to restrain the power of government to get indiscriminate access to our information. A couple more issues that, interestingly enough, I haven't seen come up a lot, in the US at least, in this particular conversation, are hacking powers. We have seen this a little bit more in the UK. The Investigatory Powers Bill does actually now put into law the ability to hack, both targeted hacking and bulk hacking, which is another interesting question, whether or not bulk hacking should be allowed, or even targeted hacking, because hacking is an interesting area where you have both privacy concerns and potentially security concerns, given that the techniques that are being used for hacking can raise security holes or increase the possibility that vulnerabilities are not going to be fixed. So that's something I think that needs a little more attention. It's getting it a bit now in the UK, but even in that debate, we've had to raise it to the fore as much as possible. It wasn't necessarily the first issue on everyone's mind. I think a lot more people have been focused on judicial authorization, for instance, and somewhat on oversight. But I do think there's a really important point in focusing initially on what powers are being sanctioned and how that authorization process in the initial phase happens too. Because I question, with regard to bulk powers, how you can ever have effective judicial authorization if you're not having that specificity that the European Court has been talking about. So one last point I'd make is that another area that I think hasn't gotten a lot of attention, and maybe we're going to talk about a little bit more now, is intelligence sharing. And this idea that information is being shared, even though laws at the national level are being changed, information is also being shared between nations. And how is that factoring into national laws? And we're not seeing it factor that much actually into the national laws in the UK at least. And also what sort of oversight can be taken when that information is being shared. Thank you.
Well, thank you. I have a couple of questions for the panelists before we move to the audience, and maybe we'll just start with that last one, Caroline. Alex or Joanna or Eduardo, can you speak to any changes in the intelligence sharing between nations? I assume you're talking about, Caroline, rules that have taken place in the last couple of years.
Sure. I mean, this is an area which we're looking at the moment in terms of intercept product and related communications data. Because there's no doubt that the relationships between the intelligence agencies in different countries are far more mature than the relationships between the oversight bodies. And this leaves us with what the Dutch Oversight Committee have actually referred to as an accountability deficit. So it's a very interesting scenario if GCHQ shared data with the NSA, and then if, for example, the NSA misused that data. Who would that be reported to? Would that be reported to the oversight body in the US? Would that be reported to us? We have a requirement to check that GCHQ are handling their material in accordance with the safeguards, which includes disclosing it to the minimum number of persons necessary, destroying it when it's no longer necessary and proportionate to retain. And I'm not sure how the NSA would feel if I popped over to America and knocked on the door and said, hi, I'm from the UK Interception Commissioner's Office. Can I just pop in and have a look at how you're handling the data that GCHQ has shared with you? So I think this is a really interesting area, and we've already started to talk to a number of our counterparts in different countries around this, and we're just undertaking an audit, similar to the audit that we did a couple of years ago around the retention and storage and destruction of material, which actually led to huge amounts of material being destroyed because it was no longer necessary to retain. We're now looking at an audit on intelligence sharing with foreign countries by the UK agencies. So we'll hopefully have a lot to report on that. And obviously topical yesterday, the Canadian shutting off some sharing of intelligence with the US. So it's a really topical and interesting area because of the nature of the communications world that we live in now.
Yeah, I'll just add that I think it's a very good topic to have continued discussions. I like the idea of oversight bodies engaging with one another in a more robust fashion. We certainly have been trying to do that, do outreach to different oversight bodies, but I think the more engagement by oversight bodies with one another, the better. I do know that when intelligence sharing happens across borders, it's very carefully reviewed and handled. It has to be consistent with both countries' laws and practices and procedures, and countries will want assurances from one another in terms of how that sharing takes place and how the information is used. So I know that there's a lot of care taken, but I agree with you, Joe, that it would be great to have more conversations among the oversight bodies.
Yes, if I can abuse my position to add a few points. One on Eduardo's thing. Yes, the courts in Strasbourg and Luxembourg have set out pretty good frameworks, but what you can really use to draw up principles by which to test proposed bills. There were two particular points, two fundamental ones. One is the court in Luxembourg has made very clear that what they call generalized access touches on the very essence of the right to privacy. In other words, indiscriminate access, and that includes, from the European perspective, indiscriminate collection, is totally incompatible with the EU Charter of Fundamental Rights. And the Americans, by trying to say that merely pulling the data is not yet collecting the data, that is totally incompatible with the fundamental principles in Europe that must be tackled. You cannot try and sweep that issue under the floor. The second issue is the fundamental principle of redress. Again, Article 52 of the Charter. You cannot be in compliance with the Charter unless you give all EU persons, not just EU citizens, full and effective redress. You must not distinguish between that. Unless the Americans accept this point, it will never be possible to come up with an arrangement between the US and the EU that will meet the EU Charter principles. It really is some very hard principles hitting on each other. Finally, on the oversight, one particular problem that's been identified by the Council of Europe Commissioner for Human Rights is the third parties rule, under which if one country provides data, shares data with another country's intelligence service, it goes always under the principle of third party clause that data may not be disclosed to anybody without the consent of the party that gives the data, and that is interpreted too often as including the oversight bodies. In other words, the intelligence agency that gets intelligence from a brother agency is not allowed to show that intelligence to the oversight body. Now that makes oversight a joke. You cannot have oversight if you cannot see that. That is one principle that must be put aside. And finally, if you talk about better cooperation between the oversight bodies, excellent, all in favor of it, but then you'll need a legal framework for it. We need a treaty under which that operates, that spells out the powers in this regard. Sorry. Sorry for taking the time.
No. Well, actually, that's a good segue to the next question I wanted to ask, which was about oversight. You know, in the U.S., there are so many different oversight bodies. I sometimes wonder when we get to the point that there's just duplication and not necessarily value add. And so I'd be interested in the panelists' views on what attributes are necessary in an effective oversight body. I mean, just to throw out a couple of ideas. One is, independence is important. So in the U.S. we have the PCLOB, we have the congressional oversight committees, the judiciary. But at the same time, sometimes oversight bodies within the agencies, because they have closer access and more day-to-day access, that can be a benefit too. So I'd be interested in your views on that. And then teeth. What kind of teeth does an oversight body need in order to strike some fear in the agency so that they will comply with rules? So we could go down the line, but Alex, I'd be interested in your thoughts on how seriously do you take for example, the congressional committees? How seriously do you take us? I could just ask that. And I'd be interested in hearing more about the European countries, and I know that there's been some movement in the parliaments of certain European countries to go closer to a U.S. model where you have intelligence committees with more vision or visibility into what the agencies are doing.
So thanks, Rachel. Yeah, I think in the United States we are sometimes I think we're a nation of lawyers where there's more lawyers than people. So we have a ton of lawyers inside the intelligence agencies who work on interpreting and applying all the legal restrictions and policy restrictions. We have functions like mine now, civil liberties and privacy functions within the intelligence community. For example, NSA has a civil liberties and privacy officer. Obviously, I've been doing this, and I've been actually doing this for a decade, so I've been doing this for a long time. And I have an internal oversight function along with my counterparts across the community, but I also have a very strong advisory function, and I'm there to try to help guide the policies and procedures at the beginning. You know, we heard this catchwords, privacy by design. That's what our offices are there in large part to do, and then, of course, to interact and facilitate oversight from external entities. So we take very seriously the oversight we get from the Privacy and Civil Liberties Oversight Board. You guys are not easy on us, as you know. We spend enormous amounts, in my view, enormous amounts of time and effort to make sure that your information requests are accurately and fully satisfied. I know that sometimes the board feels perhaps that we're not acting fast enough or promptly enough to provide the information, but we do work very hard to do that. Congressional oversight we take very seriously. Congress has the power of the purse, so in terms of teeth, Congress has the ability to set and does set the budgets for the intelligence communities. They have authorization authority. They can authorize or refuse to authorize intelligence activities. They can pass laws that restrict, like they just did with the USA Freedom Act. So congressional oversight is absolutely critical. We have specialized oversight committees. They have cleared professional staff. They have facilities in which they can receive and review intelligence information. Some member of the intelligence community seems to be up with Congress almost every single day of the week, it seems sometimes. But we are up there very, very frequently providing briefings, being in hearings, closed hearings, open hearings, providing mandated reports, responding to requests for information. So in my view, it is granular oversight. We take it very seriously. I know that there is criticisms about how Congress operates and whether or not it's effective and functional. again, from the view of someone who is overseen by Congress, it feels very, very functional and effective to us. And then there's the judiciary. The Foreign Intelligence Surveillance Court, like I said before, has sometimes been criticized for being a secret court, also criticized for being a rubber stamp. They're being more open now and providing information about how many applications we provide that they kick back, they refuse. It doesn't go to finality because of the trust in terms of I think the duty of candor is how the court has put it in their public statements that we owe the court. Now that there are cleared outside attorneys to argue the other side of cases, there's even more of a process that goes on now with that attorney getting the information they need. That attorney needs clearance. That attorney needs a clear facility in which to work. I'm very conscious of the resource requirements that are required for effective oversight. And that's just the final point I'll say is that you can't keep adding additional layers of oversight. I call it, a system of many layers with many players and additional players, and expect your intelligence community to be effective in the same way that it was before, because you are putting a demand on resources, and you can't fix that by just adding more lawyers to the intelligence agencies, because that demand, to be effective, oversight has to be informed by the people actually doing the work. So the people who are actually chasing the terrorists, who are actually analyzing the information, designing and using the systems, they're the ones who need to be in the room to provide information to the oversight entities. And that takes them away from doing their core mission. And to train and develop additional people to do that purely for oversight purposes is a difficult decision that we have to confront. It's a resource decision. I believe that we have to have oversight. I believe the oversight has to be effective, but we have to be careful about how we manage it so that we don't have duplicative, overlapping, complicated structures for the intelligence agencies to deal with.
That was quite an explanation. I'm a big believer in internal oversight. I think it can work. I think it can be very effective. I think I would agree with you on that. I think the problem is in Europe, I'm not sure it's fully trusted. And to the point where what I see all the time, mainly in the private sector, is take Germany. The role of the DPO in Germany, very often, and I don't want to offend anybody, I think everybody is doing the best job they can, but very often becomes so extreme and in seeking that level of independence, and seeking that level of scrutiny, that internal oversight can go almost the other way in terms of stopping things. So, but I think that's a very European approach to oversight, that internal oversight, that is, you have to demonstrate beyond any reasonable doubt that you are scrutinizing data practices. So that's a challenge in Europe. The other point I wanted to make, and I'll be very interested in what you guys think, is in terms of, you mentioned, Rachel, the idea of whether it was independence or teeth. I think as independence, we can take it for granted in the context of judicial oversight, I think. More than teeth, I think is power, and by power I mean decision-making power. And here's the point I'm trying to raise here. In the context of the IP bill in the UK, one of the big developments is the intervention of judges in order to authorize requests for interceptions or access, etc. That intervention, or it's a dual intervention, meaning the Secretary of State and then the judges. How do we get that balance right? And I think that's one of the aspects that has been criticized, perhaps, in the context of the IP bill. Is that judicial intervention going to be real, or is it rubber stamping? And getting that point right of going beyond the rubber stamping and, again, beyond reasonable doubt, this is going to be a real decision-making power, I think that's critical in addressing the point you're raising.
I think just to add to that, yes, there has been a huge amount of debate about the principle of judicial review, and again, the Home Office yesterday have submitted more evidence on how they believe that's a flexible test, and that in this type of activity, it would mean looking at the necessity and proportionality case and not just checking that it was an unreasonable decision, if you like, by the Secretary of State. But what I want to talk about as well is it's not it's also important to look at the post facto oversight. And there's been so much focus on the judicial pre-authorization when actually the majority of the oversight takes place after the authorization has been given. And the majority of our time as an oversight body is looking at the material that's been collected, whether it's been retained and stored and destroyed in accordance with the arrangements in place. We look at and test the considerations that were made in relation to intrusion, and we look at actually, were those borne out, or actually was the intrusion far higher than was foreseeable, and as a result the conduct's become disproportionate. And in those scenarios, we'll recommend that an authorization is altered or indeed cancelled in some occasions. And it's that post facto oversight after the authorization has been given that it's really important to get right. And that's where you need more than just judicial legal skill. That's where you need technologists, you need engineers, and you need a real analysts and a makeup and a breadth of skills to actually get that right. And that's an area which we're developing, and we've worked with a lot of private companies who've built query-based searches and functions into the law enforcement and agency systems. So now we're able to, in bulk, if you like, search for compliance issues and highlight at the touch of a button compliance issues post-authorization. So that's such an important factor, and I don't think the IP bill accounts for that properly yet.
Just to add a little bit to what's already been said, and maybe focus on the issue of independence in particular, I do actually think, and I hear some of the practical considerations here about why independence can be difficult to implement, but I think it's a really important factor, and we've seen, for instance, in the UK a bit of a failure, particularly with the Intelligence and Security Committee, when they didn't have much independence, the ability to, which is the parliamentary committee, or now parliamentary committee that was overseeing the intelligence services in the UK. So I think it can be a really important factor, and I think what ties into that is properly resourcing oversight, particularly giving oversight the technical resources, because while I hear that may be expensive to give independent technical resources to oversight bodies, if they're relying on the very agencies to, who are carrying out the surveillance to then ask them if this is technically appropriate and do their technical analysis, then that makes it obviously really difficult to get a full critical view of what is happening, especially when it comes to new powers like hacking. So I think that if oversight is going to be effective, it needs to be independent, especially technically independent, and have the resources to back that up. In addition, one of the things that we keep on running into both in our court cases and with the oversight bodies is this idea of the ability to actually publish information about what has happened. I think the presumption should be in favor, especially when it comes to policy opinions, legal opinions, the presumption should be in favor of openness, not secrecy. Because if you don't have that presumption, then a lot can be put under the rug, and you end up needing to rely on whistleblowers and others to bring that information forward, whereas I think if we had those discussions first time around, and oversight bodies I think can be very effective in that way, then we could see a lot more effective regulation of these powers.
We'll move to questions from the audience now. I just want to make one point along those lines. I agree with that last point that you made, and one thing that my agency was able to do in our lengthy public report on the Section 702 program was to, much of that had already been declassified after it was leaked, but there were still a number of aspects of the program that were classified, and we were able to work with the intelligence agencies to get a number of additional facts declassified in order to be able to publish them in our public report. So that is something that we take seriously as well. In the last panel, the moderator collected several questions and then put them collectively to the panel, and we can do the same here. Is there a microphone back there? Okay. Go ahead.
Do you want me to go first? Or?
Sure.
Okay.
Could you identify yourself, please?
Sure. My name is Sarah St. Vincent. I work for the Center for Democracy and Technology, where I work on surveillance and human rights issues. My question is about oversight in the United States. And the question I wanted to ask is basically this. I think that one of the most wonderful aspects of the Privacy and Civil Liberties Oversight Board is that it is gender balanced, and it's also relatively politically balanced. What I would like to ask both you, Ms. Brand, and you, Mr. Joel, is do you feel that the oversight processes in the United States adequately represent the interests and views of communities that in the United States have historic and other reasons to be particularly concerned about abuse of surveillance. I'm thinking particularly, but not exclusively, of the African American and Muslim American communities. Do you wish that there was more representation there? And if so, how might we be able to bring that about? Thank you.
Okay, was there another question in the, I see a couple more hands up. Maybe I see 3 hands up.
I think I got the second microphone, so I would probably go ahead. Max Schrems, I brought the case at the European Court of Justice. Thanks a lot for what you said before. I have actually 4 short questions. The first thing is, in the debate in the US, it was oftentimes really about that US people are not surveilled, but I hardly heard, and also the reports a lot are not too much about foreigners not being surveilled. I was wondering how much oversight you see in this respect in the US right now. The second question I had, okay, now the screen is going dark, is right now, where does a European go if I feel that my data, for example, is tapped into? What is actually the place where I could possibly go to in the US? I'm also looking forward to like a Safe Harbor 2.0. Third question, Peter Swire said that the Fourth Amendment actually applies to me if my data is tapped into in the US. I was wondering what your views are on this, because I wonder if the laws would work then. And the last thing that I thought would be interesting, if you could kind of explain how the factual access actually works in these mass surveillance programs, because that's something I could hardly find in any of the documents. And I don't know if you can disclose that or if that's secret in any ways, but it would be interesting to know how technically data is accessed, for example, on Facebook or any other service provider.
There was a question here in the, go ahead.
Thanks. Charles Rabb, University of Edinburgh. I want to take up Eduardo Ustaran's point about finding a balance and so forth. I've been a long-term critic of the idea of balance in this domain, and it's very interesting to see that the U.S. President's Review Group in 2013, one of the authors is present in the room, being Peter Swire, said the following. Said the United States government must protect at once 2 different forms of security, national security and personal privacy. And they went further and they said the idea of balancing has an important element of truth, but it's also inadequate and misleading. I won't continue with the quote because time is short, but the point that they made and was picked up also in the Rusi report that Joanna referred to was that there seems to be very little conceptual understanding of what privacy is all about, and indeed what security is all about, as though we all know what privacy is, we all know what security is, and the courts give us a clue as to how to balance. Well, we're not talking about what the courts do, we're talking about oversight organizations. We're also trying to see what their understanding might be of these 2 things, which are not opposite sides of a spectrum that need to be balanced in the middle, but are fundamental aspects of each other. There's no security without privacy. There's no privacy without security. And that complicates what an oversight body might do in making judgments about the permissibility of the things that they are meant to oversee. In the UK, I think the Intelligence and Security Committee doesn't understand this, and let alone do they have the technical capability, which Caroline and Joanna referred to really get into the issue. So what I'd like to do is to ask people, please, not simply to jump to the mantra of balance and think that will give us an answer to how we relate privacy to security, because it's far more complicated than that, and we need to have more inputs into that understanding. Thank you.
Thank you. We only have about 8 minutes until the end of the panel, and I want to give each of the panelists a question to address all of the questions. I see there's one more. Okay, we'll take it very quickly.
It's a very quick question. We've had a massive push from our American friends at CPDP this year about how good oversight...
I can't hear you. Could you talk into the microphone?
Oh, sorry. We've had a very good push from the Americans over here this year about how good the oversight on various things are in America. Can you name 5 programs that Edward Snowden revealed that would now be completely unlawful?
I guess there was one more in the front, and that's the last one. Do you have the microphone?
I know it's working now. Following up Max Schrem's question, a very specific question for you, Rachel, actually, because my understanding is not clear on precisely the programs that PCLOB looks at? You mentioned counterterrorism programs. I wondered how far you also look at foreign intelligence and other programs which are, many Europeans would say, affecting their privacy, but I'm not sure if they're within your remit or not.
Okay, well, I think those are the questions that we'll let everyone go down the row and have 1 minute of response to them collectively. As to your last specific question, our statutory mandate is limited to counterterrorism. So, for example, if there's a counterintelligence program, catching spies, we don't have jurisdiction over that. And obviously, some surveillance programs would collect information relevant to counterterrorism and other functions. So we could look at that program. We're not somehow going to look at half of it, but the statute does talk about counterterrorism specifically. I think your question about balancing is quite interesting. A lot of people don't like the word balance as in the same way that you don't like it, and I will confess to having used it because it's a convenient shorthand to describe something that's actually hard to find a word to describe, which is, I think it's not balanced in terms of a zero-sum game. It's not like you have more security, so you necessarily have less privacy or vice versa. It's more keeping two things in mind at the same time and doing them both well together. And that is a very hard challenge, but you have to do both. So, for example, although I am a member of the Privacy and Civil Liberties Oversight Board, my job is not to only think about privacy and never think about security. It's to think about both and think about how to achieve both. You can call that balance, you can call it something else, but that's what I view my job as doing.
Thank you. So I'll try to hit a couple of these very quickly. So Sarah, on your very good question about pointing out particular communities, I won't speak for oversight entities or others, but just for ourselves at the ODNI, we've met with representatives of the Muslim, Arab, Sikh, and Southeast Asian, Pakistani American communities. We've met with them a few times. We're going to continue to meet with them. It's part of our engagement with civil society. We think that's a very important segment of civil society. They have concerns about being unfairly singled out, and how we communicate, in particular, our focus on terrorism. We have to take their sensitivities into account, protect those communities from being unfairly discriminated against, and getting a sense that I think the term that we've been using to capture some of those issues is securitizing our relationship with very patriotic and important part of the American system. So we do take that seriously. It doesn't quite get at your oversight issue, but it is an engagement and outreach thing. Just in terms of like judicial redress inside the United States, the Privacy Act is our statute that people tend to look at. It does apply only to U.S. persons, but we do have other statutes that we are frequently sued under. We are well and amply sued in the United States because, like I said, there's more lawyers than people. So, for example, the Freedom of Information Act does not distinguish by nationality. Okay, and finally, there was one other.
4 minutes.
Oh, well, okay, I'll just keep on going. I'll let you deal with it.
Okay, so I wanted to pick up on the point of inadequate and misleading. Well, first of all, I would not dare to criticize Peter Schreier's good work on this, but the point I'm trying to make is that the Court of Justice of the European Union, which is as objective, I think, as you can get, right, proves that balance is possible. And by balance, again, okay, let's replace the word pragmatism. Okay, pragmatism, finding a solution, finding a way of, and I agree with you, Rachel, I think you have to find a way of achieving both ends, both aims, and it's as simple as that. And to be honest, even in the latest case, the Max Schrems case, the court proves that once again, it is possible to find a solution. It's all a matter of getting, from how I understand the case, the two key priorities that the court is looking for, and for those negotiating safe harbor, just a reminder, are, number one, the proportionality of the access to the data, and secondly, the oversight or redress aspect of it. You get those things right, you get the solution.
I just had a quick thing on Charles's question. I think a good development in the UK, I mean, proportionality, as Eduardo said, is the key here in terms of assessing proportionality on a case-by-case basis, which is a lot harder than meeting the test of necessity, in my view. But I think an important development in the UK is within law enforcement, there's now a digital ethics panel. And this is a really interesting initiative because what they're looking at is actually the ethics of using some of these surveillance powers. So they're saying, well, this might be lawful and we might be able to meet the tests of necessity and proportionality, but actually, is this conduct ethical? And if we want to police with consent in the UK, then we need to be looking at not just the legality of what's proposed, but also the ethical considerations. And I know Charles is heavily involved in chairing that panel, and that's a really good initiative.
Sure. I'll just make this very quick, picking up on the redress point, which I already spoke on a bit earlier. But one important aspect of getting into court, even if there is statutory authority or potentially constitutional authority in the U.S., is also the idea of notification and knowing that you've actually been under surveillance. And that's an issue that's going across both sides of the Atlantic, especially when it comes to intelligence agency surveillance, but also with regard to the police. So I just think that's something that to keep in mind, that notification is an important component of redress, because if you don't know if you spied upon or can't prove it, then it's hard to get into court.
And just on the Fourth Amendment question, the Fourth Amendment applies inside the U.S., period. So that's the answer to that question.
Shall we? Yes, I think we got to call this to an end and allow people to have lunch. I think it was extremely good of the US mission to the EU to organize this. It is very useful to have these conversations. We have similar dilemmas on both sides of the Atlantic. It's not going to be easy to resolve them. Reconciling, that's the word. Let's not balance, let's reconcile. But I hope this is a step in that direction, and thank you very much, and can you please show your appreciation for the panel. Thank you. Thank you. Thank you. Very nice.